Okay. In usage, when Marxists use the term, they use term freedom, but that does not mean that the capitalists and liberals don't use the term freedom. Okay. Marx has used freedom in a very specific sense of the term. Is this clear? So for a general studies student, liberty and freedom is same. This one point you have understood? But there can be a confusion in the sense, if we look into part 3 of Indian Constitution, okay, fundamental rights, Article 19, you know, right to freedom. Now, Article 21, right to life and personal liberty. Okay. Now, here like right to freedom includes freedom of speech and expression. This also includes right to personal liberty. Okay. You can ask why the term liberty and freedom is used. Liberty is used here, freedom here, and what is the difference? Any idea? Liberty and freedom. Any idea here? Difference? Liberty is used for individual. All rights are used for individual only. Freedom used for? Freedom is not?
Absolutely. It can be suspended during emergency.
Freedom cannot be suspended. Article 19 cannot be suspended. Article 21 can be suspended. Article 19 though can be suspended only in case of emergency. आर्टिकल यही चीज़ें जो है ना, पॉलिटी में कुछ भी यू कैन नॉट टेक इट फॉर ग्रांटेड कि हम समझ गए, मिल ने ये बोला था, ऐसा होता ही नहीं. ठीक है, क्योंकि ये बहुत ज़्यादा ज्यूरिस्टिक डिसिप्लिन है. ठीक है, तो अगर मुझसे ये क्वेश्चन पूछा जाए, why the term liberty is used here, why not freedom, I have no answer. You understand in this? They could have used the term freedom also. It was their choice. But if you will ask me the question, what is the difference in the liberty here and the freedom here, I can tell. Are you confused? If I say, will it make any difference if instead of the word right to life and personal liberty, the term freedom is used? Will it make any difference? My answer is no. ठीक है? You can use anything. They have not distinguished these two words in terms of any ideological difference. But the nature and scope of the freedom here differs from the nature and scope of freedom here. This is like a very nuanced difference. You need to be very alert to understand this, what I am saying. It would have made no difference. They would have used freedom here or liberty here. Liberty here, freedom here. We are not making, but there is a difference in Article 19, the freedom we enjoy, and Article 21. Right to die कहाँ पे है?
Like 21 is available. 21 is available for all, ma'am, even non-citizens.
21 is available for all.
And freedom has been used specifically for citizens only. And
That is one difference, but not the.
Maybe because right to life is like a person is born, then it has some influence because that person is born right to with him and
Forget it. Okay. Now I am starting from the question he asked. What is the difference between these two terms, freedom and liberty? So for GS students, no difference. It can be used interchangeably. Is that clear? So you write this first. Right? No difference in freedom and liberty. Here as a note you write, some political philosophers like Karl Marx preferred to use the term freedom because the term liberty got associated with liberalism, comma, which got associated with capitalism. Is this clear? Now, you can also write, if Marx defines freedom, in what way? Freedom is liberation from something. So, for liberals, freedom is freedom from the customs and traditions, the freedom from the absolute powers of the state. Because in the West, freedom concept has evolved. But for Marxists, what is freedom? When man is free. When man is free, when he don't have to worry for his bread and butter. So Marxist defines freedom in terms of freedom from basic necessities. Marxists say, till my basic necessities are not fulfilled, the rights which I have, they are empty. ठीक है? I may have right to freedom. Fine. I may have rights under Article 19. But these rights will carry no meaning if I do not have bread and butter. Anybody can purchase my rights. So real freedom is freedom from basic necessities. Is this clear? If you see Indian Constitution, fundamental rights, directive principles. So directive principles are based on socialistic ideology, fundamental rights are based on liberal. अब liberal ideology में primacy individual को है, individual and his rights, ठीक है. और यहाँ पर है economic, social and economic rights, right to work, right to wages, right to food, right to education. ये समझ में आया, ठीक है. So now fundamental rights, they make India political democracy because they limit the powers of the state. These rights, they are also rights. They make India social and economic democracy. Is this clear? Because it deals with social and economic rights. तो अगर हम इंडिया की बात करें तो इंडिया हैज़ अ कॉम्बिनेशन ऑफ सोशल एंड पॉलिटिकल डेमोक्रेसी. To quote Ambedkar, what Ambedkar said? He said that political democracy, don't write anything, I'll tell. Political democracy without social and economic is a contradiction. Okay? And his famous speech, The Grammar of Anarchy, and what he said that democracy is a topsoil of Indian society, and we are today, we are entering into the life of contradictions. What contradictions? We have established political democracy but no social democracy. So sometimes they can ask you a question, discuss the idea of democracy found in the preamble or the constitution also. Have you understood these debates? Okay. So rights, freedom, now it is clear. Marx, have you defined how Marx defines freedom? No. So you can write, just as a note you write, Marx oblique leftists define freedom in terms of, right inverted commas, freedom from necessities. Which means fulfillment of the basic needs. ठीक है. आप एक क्वेश्चन लिखो. दो in detail I will discuss in fundamental rights chapter, but because we are discussing liberty, freedom, so you can write question, compare right to freedom given in Article 19 with personal liberty given in Article 21. बहुत ही केयरफुल होना होगा पॉलिटी के क्वेश्चंस प्रीलिम्स में करते समय, ठीक है. अब हाउ मेनी ऑफ यू हैव idea on fundamental rights? Rest of you don't know your fundamental rights? You know at least 6 fundamental rights. In newspapers or at any other place, have you ever heard about Menaka Gandhi case?
Yes, sir.
Okay. Why it is known? What is the importance of this case?
Right, it was only what he was doing.
You know any idea about Menaka Gandhi?
Ma'am, the golden triangle rule was defined like
The golden triangle.
rule. Article 21, 19, 14, the interrelationship between
14, 19 and
21.
21. What else? Huh? Due process of law. Fine.
And natural justice was also
Natural justice. Okay. So there are many things with the, see which institution is the ultimate interpreter of the Constitution? Supreme Court. And is it right to say that Indian Constitution is a organic document? What does this mean, organic?
evolving.
नेचुरल है. ऑर्गेनिक का मतलब होता है नेचुरल. नेचुरल का मतलब होता है लिविंग बीइंग. तो आवर कॉन्स्टिट्यूशन इज अ लिविंग कॉन्स्टिट्यूशन. लिविंग और इट इवॉल्व्स. ओके, तो दिस यू राइट, ऐसे लिखो. क्वेश्चन का आंसर तो बाद में लिखेंगे, पहले लिखो इंडियन कॉन्स्टिट्यूशन इज एन ऑर्गेनिक डॉक्यूमेंट. which means natural oblique living. So living means it evolves, okay, right? It means it evolves. Now tell me, what are the methods in which our constitution evolves? By amendments. Okay. Okay. Any other way?
Supreme Court interpretation.
Interpretation of the Constitution. These interpretations keep on changing. Judiciary changes its interpretation. So our Constitution is amended. Even if I say Indian Constitution can be amended in an informal manner also. Is it right? Informally it is amended through judicial interpretations. ठीक है? More amendment, who does more amendment? Parliament or judiciary? Judiciary. ठीक है? तो इनफॉर्मली ज़्यादा अमेंडमेंट्स हैं, फॉर्मल भी कम नहीं है अपने यहाँ. ठीक है? तो बट इंटरप्रिटेशन. सो जुडिशरी गोज फॉर इंटरप्रिटेशन and judiciary keeps on changing its interpretations. ठीक है? So Menaka Gandhi case is a case after which lot of things have changed with respect to the interpretation of Indian Constitution, before and after. Is this clear? So you can say that after Keshwanand Bharti case, the second case of judicial activism is Menaka Gandhi case. After that there was no judicial activism till Minerva Mills case. Okay? So these two cases, they had made a huge difference in the meanings and the interpretations of the provisions. Is this clear? So in detail we will go in Menaka Gandhi case later on, but to understand the difference liberty and freedom, because this issue came, you can just write this, that write Menaka Gandhi case is a milestone because it made a huge change in the interpretation of the provisions of the Constitution. ठीक है? And what is the biggest change? लिखो, what is the biggest change it made? What is the biggest change it made? इसमें write, it made biggest change with respect to the interpretation of Article 21. ठीक है? अब जस्ट लिखो टेक्स्ट ऑफ आर्टिकल 21. If anybody of you find it difficult, then let me know. Is it fine? You are understanding? Text of Article 21. What is the text of Article 21? Right. State shall not deprive a person from his life and liberty except according to the, right inverted commas, procedure established by law. ठीक है? Now here see this constitution and its meaning and the relationship of 19 and 21. Lot of things have changed before Menaka Gandhi case. Is this clear? And Menaka Gandhi case is an example of creative interpretation of the constitution, where judiciary itself interpreted the constitution very differently from what the constituent assembly had made. Okay? So right now we will try to understand, because our purpose is to understand 19 and 21 and the difference. So let us understand as the original constitution. Things have changed after Maneka Gandhi case. So now what I am explaining is as per the original constitution. ठीक है? So here again you can write interpretation before Maneka Gandhi case. Yeah, basically original constitution. ठीक है? Now, this, when the term state was used, is used in original constitution, state, you know, there are 3 branches of government. Okay? Executive, legislature and judiciary. Okay? Where will you put police? Executive? Okay. So in original constitution, this state represented which institution? Now, does it include judiciary also? No. ठीक है? State, जैसे अभी तो हम लोग फंडामेंटल राइट्स की बातें काफ़ी करने लगे हैं फिलहाल, तो आर्टिकल 12 में स्टेट की डेफिनेशन है, उसमें जुडिशरी नहीं आता. ठीक है? मतलब जुडिशरी के अगेंस्ट रिट्स नहीं ले जा सकते हो. ओके? जुडिशरी, you cannot demand, you cannot use article 32 against judiciary. Have you understood this? जुडिशरी तो आता ही नहीं. रह गया लेजिस्लेचर और एग्जीक्यूटिव. ये पहले स्टेट ये किसको डिफाइन कर रहा था? स्टेट शैल नॉट डिप्राइव. वॉज दिस डिस्क्राइबिंग लेजिस्लेचर एंड एग्जीक्यूटिव बोथ or only executive? Both? No. Only executive. और executive का मतलब है पुलिस. Who deprives me from my liberty? हमको जेल में डालता कौन है? पुलिस. ठीक है? तो इसका मतलब है पुलिस. Shall not deprive a person from his life and liberty except according to the procedure established by law. Who will make law? Legislature. If legislature has made law, let us say preventive detention law, and the preventive detention law says there is no need to take this person to the magistrate. You can put him behind the bar, let's say for 3 months at a time. Okay? Then the police is right in doing so. Can you get a writ of habeas corpus then? No. Okay? So, police cannot deprive me arbitrarily. But if there is a law, law says so, they can do so. Is this clear? So basically, what was the difference between Article 19 Article 19 is a right of a person who is free. Article 21 is the right and protection of the person who has been detained by the police. 20, 21, 22, these three articles, they deal with criminal justice system. 22, don't write, I will do it in fundamental rights. But because he asked this question, so I am clarifying it. But this situation was only till Menaka Gandhi case. After Menaka Gandhi case, no difference in the liberty here and freedom there. In original constitution only, 21 was, I am invoking these rights when police has arrested me. These are the rights which are rights of a free person. Is that clear? So, as per law, if person or police is detaining me, it can do so only by law, not in an arbitrary manner. Now you got the answer of your question. But this was there only till Menaka Gandhi case. So basically, till Menaka Gandhi case, liberty term here was absence of confinement. ठीक है? Liberty term was used in a very limited sense. But in Menaka Gandhi case, Supreme Court held that liberty is not just absence of confinement. Liberty includes doing all those things which I want to do, including my right to carry a passport and to travel abroad. Since then, liberty and freedom used here and in 19, it has become same. Now you have understood this? क्या बता दें? मतलब पुलिस ने मुझे कन्फाइन करके रखा है. उस समय यहाँ पर पहले मीनिंग क्या था राइट टू लाइफ का? एब्सेंस ऑफ डेथ. लेकिन अभी इंटरप्रिटेशन से क्या कर दिया है? राइट टू लाइफ इंक्लूड राइट टू लिव इन अ क्लीन एनवायरनमेंट, राइट टू एजुकेशन, राइट टू प्राइवेसी. तो ये सारे डेवलपमेंट्स 80s के बाद के डेवलपमेंट्स हैं. 80s से पहले हमारा कॉन्स्टिट्यूशन अलग था. 80s से पहले जुडिशरी अलग बातें करती थी. 80s के बाद से अलग बातें करती है. वही है हमारा कॉन्स्टिट्यूशन. क्या है? लिविंग डॉक्यूमेंट, बदलता रहता है. ठीक है? अभी समझ में आया या कंफ्यूजन बढ़ गया? क्या लिखवा दें? अरे तुम्हारे राइट्स हैं, तुम्हें पता होने चाहिए. हाँ, तुम्हारे राइट्स पढ़ाने की जरूरत होती है. फंडामेंटल राइट्स के लिए तो वी फॉट इंडिपेंडेंस मूवमेंट. इंडियन इंडिपेंडेंस मूवमेंट इज व्हाट? सिविल राइट्स मूवमेंट, मूवमेंट फॉर फ्रीडम ओनली. टुडे हाउ पेन्ड द लीडर्स विल बी when you say I don't know my fundamental rights. You know, people have sacrificed their life. Remember Bhagat Singh. Today you will say tell me rights. ठीक है? So I think fundamental rights is the whole purpose of our freedom movement. उसको तो कुछ बताना ही नहीं है. वो तो तुमको कैसे पता होना चाहिए? The moment you take birth, you should know what are my राइट्स. ठीक है? फिलहाल अब मुझे बताओ, कॉन्स्टिट्यूशन में लिबर्टी और फ्रीडम इज डिफरेंट और सेम? सेम. कॉन्स्टिट्यूशन में द कंसेप्ट ऑफ लिबर्टी टुडे sorry, the concept of liberty in 19 and 21, same or different? It has become same since Menaka Gandhi case. Earlier it was different. What was the difference? Under Article 19, it was the freedom of free person. Free person क्या क्या करता? Freedom of speech, freedom to form association, freedom to go, settle, ये सब कर रहा था. और ये वाला personal liberty था, that I cannot be detained in an arbitrary manner by the police. Got it? You want to write this? Okay. What was the subheading that I told you? Before Menaka Gandhi case. So write first point. Right. Till Menaka Gandhi case, Article 19 denoted right of a free person. Full stop. It included many rights. Comma. Some written in explicit sense, explicitly, and some implicitly. जैसे फ्रीडम ऑफ प्रेस क्या था? इम्प्लिसिट. ठीक है. नेक्स्ट पॉइंट, आर्टिकल 21 dealt with the right of the person, detained by the police. Right. Here personal liberty was used in a limited sense. That is absence of confinement. Right. Even right to life was used in a limited sense. That is absence of death. Absence of death. You are living मतलब मरे नहीं हो, किस हाल में तुम जी रहे हो इससे कोई लेना देना नहीं. ठीक है. तो हम क्या कर रहे थे? लिमिटेड इंटरप्रिटेशन. ठीक है. नाउ if we see, there is also one issue of due process of law. You are clear with that? Due process of law. Let me explain. Okay. So, if you see the tradition of law in a democratic country, there are two traditions. many others, but right now let us talk only two. One is a British Constitution. Okay. Second is American Constitution. Now tell me, people have fundamental rights in Britain? Yes? What is the source of your information? उनके पास कॉन्स्टिट्यूशन नहीं है, कन्वेंशन से फंडामेंटल राइट्स हैं, और दे हैव राइट टू इन्फोर्समेंट, बिल ऑफ राइट्स. सी, again, have you heard about this concept? Parliamentary ठीक है. Britain has parliamentary sovereignty, means parliament has all powers. India has parliamentary sovereignty. You have parliamentary democracy, but no parliamentary sovereignty. We have sovereignty power. We have which sovereignty? Our sovereignty lies with people. Okay? And can we say in India constitution is supreme? But in Britain, constitution is not supreme. Parliament is supreme. So parliament can make any law. Is there any limitation? No limitation. So suppose you have any right in Britain. In Britain, can there be a concept of a fundamental right? You know what is fundamental right? Fundamental right is which is fundamental to your existence. अगर वो right तुमसे ले लिया तो तुम खत्म. You understanding this? फिर तुम नहीं रहे. Have you understood this? So fundamental right. I am nothing without the fundamental right. They are fundamental to my existence. Okay? Will I allow legislature to take those rights? No. Means fundamental rights are limitations on legislature's power or not. Can legislature make any law which abridges me of my fundamental rights in India? No. Where is this limitation written? Constitution, Article 13. So that is a limitation on the sovereignty of Indian Parliament. But is this situation prevail in Britain? No. So in Britain, citizens do not have fundamental rights. They only have customary rights or legal rights. They enjoy only those laws, only those rights which is given to them by state or parliament. तो जहाँ भी पार्लियामेंट्री सॉवरेनिटी होगी वहाँ पर राइट्स फंडामेंटल नहीं हो सकते. तो ब्रिटेन में फंडामेंटल राइट्स हैं? नहीं है, लेकिन लक्ष्मीकांत में लिखा हुआ है, इसीलिए तुम लोग बता रहे हो. लेकिन लॉजिक को समझना बड़ा इम्पोर्टेंट है. हो ही नहीं सकता fundamental right makes individual sovereign. We are sovereign. Popular sovereignty है, हमारे पास sovereignty है, पार्लियामेंट के पास sovereignty नहीं है. पार्लियामेंट वही कर सकता है which we allow them to do. Is this clear? And we have not allowed them to deprive us from our rights. Is this concept clear? Okay. So, in law, in Britain, you have a principle of parliamentary sovereignty. Means there is no restriction on the parliament's power. You can write, in Britain there is a principle of parliamentary sovereignty, which means no restrictions on the power of parliament to make law. So, however, this did not remain fact because Britain joined European Union, and when Britain had joined European Union, Britain had to follow the European laws. So, one of the issue in Brexit is that they want sovereignty back in the parliament. British Parliament should determine the immigration policies, the health policies, and they believe that EU has taken away the sovereignty. So, by Brexit, what Britain will get it back? Parliamentary sovereignty. Okay? But theoretically, it follows the principle of parliamentary sovereignty. You have written no limitation on the power of parliament. Now, if parliament is supreme and there is no limitation on the law-making power of parliament, can judiciary challenge the wisdom of the law? No. So, in Britain, judiciary cannot challenge law. ठीक है? कहने का have you heard about the term judicial review? तो is judicial review a condition for rule of law? It is a condition because judiciary ensures neither legislature nor executive does anything which goes against law or against the constitution. ठीक है? बट अगर यहाँ कॉन्स्टिट्यूशन सुप्रीम नहीं है तो ब्रिटेन में जुडिशरी हैज़ पावर ऑफ जुडिशियल रिव्यू only on executive acts, not on legislative act. It cannot question the wisdom of law. It can only question executive act. This is clear? Any confusion, many things coming? No? Then you write. In Britain, judiciary has power to review the executive acts full stop, right? It cannot review the legislative acts. Is the principle of judicial supremacy exist in Britain? सुप्रीम तो एक ही होगा, पहले से ही डिसाइड है, पार्लियामेंट. Judicial independence is a different thing. Judicial supremacy is different. Is this clear? So in Britain judicial independence exists. तो independence और supremacy सब confuse हो के आओगे वहाँ पे एग्जाम में. You will get confused. कुछ का कुछ मार के आओगे. You will play with your marks. Independence and supremacy is different. Keep it in mind. Okay. Now, in America, Constitution is supreme. It means there will be limitations, right? It means there will be limitations on the powers of both executive as well as legislature. Right? Judiciary can challenge even the wisdom of law. Now, if I say supremacy of the Constitution and supremacy of judiciary is same, is it right? In India, Constitution is supreme or judiciary is supreme? Or is it same thing? No? Different? Is judiciary under the Constitution? Judicial appointment is as per the Constitution? Yes? In the Constitution that collegium system is given. Judiciary acts according to the Constitution in India. हाँ? Independent तो है ही है. It is controversial. लिखो यहाँ पे लिखो. Right? Constitutional supremacy and judicial supremacy is one and same thing, is the same thing. अब लिखो why. Right? It is said that comma, we are under the Constitution. Comma, but Constitution is what? Judges say. Constitution is what? Judges say. तो जजेस ही बता देंगे कॉन्स्टिट्यूशन में लिखा हुआ है जुडिशरी सुप्रीम है. ठीक है. तो जहाँ भी कॉन्स्टिट्यूशन सुप्रीम होता है वहीं पर जुडिशरी अपने आप ही सुप्रीम हो जाती है. ठीक है. कॉन्स्टिट्यूशन में क्या लिखा है, बट उसका इंटरप्रिटेशन जुडिशरी सेज सो. इज दिस क्लियर? सो interpretation of the written constitution has been changed by Indian judiciary. Okay, so Indian judiciary not only acts as a parliament, it also acts as a constituent assembly or supreme legislature. Two cases. First is Keshwanand Bharti case. The other is मेनका गांधी केस. ठीक है, तो असलियत में कॉन्स्टिट्यूशन इज सुप्रीम, एंड वेयर एवर कॉन्स्टिट्यूशन इज सुप्रीम, फंडामेंटल राइट्स आर देयर, जुडिशरी automatically gets the primacy. Is this clear? So British system is this tradition. When you say this word, procedure established by law, this is a British tradition. Okay. Second, due process of law is US tradition. Due process of law is a US tradition. ये समझ में आया? तो ड्यू प्रोसीजर established by law, ये क्या है? This is a limitation only on the action of executive. यहाँ पे लिखो इसका मतलब क्या होता है. It is a limitation only on the action of executive. Means judiciary challenged the wisdom of executive act, but not legislature. जुडिशरी तो चैलेंज करती है, लिमिट. हाँ, प्रोसीजर एस्टैब्लिश्ड बाय लॉ का मतलब होता है पुलिस कैन टेक एनी एक्शन या एग्जीक्यूटिव इज अंडर द लॉ. उसी लिए तो रूल ऑफ लॉ आया है. किंग क्या था? पहले डिवाइन राइट था, किंग का जो मन में आता था वो करता था. तो डिवाइन राइट एंडेड, नेचुरल राइट्स केम. तो रूल ऑफ लॉ का एक कंसेप्ट क्या है? इक्वालिटी बिफोर लॉ. यू नो द मीनिंग ऑफ इक्वालिटी बिफोर लॉ? What is the meaning of equality before law? Everybody is equal in the eyes of law, which means equality is absence of this prelims. In last year prelims this question came. What is equality? Absence of what? Privileges. Who had privileges? Common man or king? King. So when this principle was pronounced, equality before law, it meant what? Even if you are a king, you are under the same law. You will be tried by the same judges. You will not demand any special treatment. Is this clear? So equality before law. Is that clear? This is a principle. So this is called as procedure, or basically this is the British tradition. ठीक है, equality before law. And ये यहाँ पे कहाँ से आया? वैसे हम कहाँ से आ गए? How come from procedure? What was the question? Somebody asked the question. 19 and no. Okay, I was explaining procedure established by law. That means that even if you are king, you are under the law. You can act only according to the law. It means police can arrest me only if there is a law. Is that clear? So normally when you use the term state, it is used for executive. When you use government, primarily executive comes in our mind. Have you understood this? So procedure established by law means you are not free to do whatever you want. There is a rule of law. You have to act according to the law, and you have to follow the procedure which has been mentioned in the law. So the IPC says so, CRPC says so, you have to follow that. Basically CRPC. Have you understood this? Okay, the meaning of procedure established by law. ठीक है? तो right, it is a limitation. इसका मीनिंग क्या है? It is a limitation on the executive, sorry, on the power of the executive. Right? Executive cannot act in a arbitrary manner. Next, it has to act according to the procedure established by law. Next, it is primarily concerned with the criminal justice system. ठीक है? CRPC, Code of Criminal Procedure, you cannot arrest me without warrant, this, that, ये इससे लिंक्ड है. ठीक है? अब ड्यू प्रोसेस ऑफ लॉ लिखो. ड्यू प्रोसेस ऑफ लॉ. At times it is also called as natural law. Pardon? Natural law. Basically not natural law, you can say natural justice. It is a principle of natural justice. Why it is a principle of natural justice and all? No need to go into the detail. In political science we study the theory of Locke, and then you will understand this natural justice and this principle. For general studies it is enough to know due process of law. ठीक है? or as you say, natural law. Now, there is a natural law, you know. Natural law means which is not written, which you understand by use of your reason. ठीक है? तो natural law is not written, it is understood by reason. This point is clear. So here you write, then I'll explain. Right? Natural law is not written. It is understood by reason. किसके रीजन पे डिपेंड करता है? क्राइम किया है उसके पास तो रीजन ही नहीं, उसने क्राइम किया है या नहीं किसके रीजन पे डिपेंड करता है? जजेस. नेचुरल लॉ लीव थिंग्स ऑन द जजेस. ठीक है, दिस इज राइट एंड रॉन्ग. एनीवे, डोंट गो इनटू दैट डिटेल फर्स्ट. तो इट इज बेस्ड ऑन प्रिंसिपल ऑफ नेचुरल लॉ which is reason. Natural law और reason एक ही बात है. Okay? Now, what is the due of law? Law is for what? You have created the system of law for what? Justice. Okay? Due of law is justice. Justice, injustice can be understood by your reason or soul. In political science class I was explaining this. Justice, injustice को पढ़ने के लिए या समझने के लिए गाइड क्या है? सोल और रीजन. ठीक है? जस्टिस. तो व्हाट डज प्रिंसिपल ऑफ ड्यू प्रोसेस ऑफ लॉ सेज? दैट बाय मेकिंग लॉ, हु मेक्स लॉ? लेजिस्लेचर. यू कैन नॉट डू इनजस्टिस. You can, this means you cannot make unjust laws. तुमने कहा हम पार्लियामेंट है, हम लॉ बना रहे, बट एनी लॉ मेड बाय पार्लियामेंट कैन नॉट बी एक्सेप्टेड. इट कैन बी unjust. Okay? So judiciary gets power to question the wisdom of law, not just the power of or power to question executive. ये समझ में आया? इसके लिए तुमको समझना पड़ेगा नेचुरल लॉ का एक कंसेप्ट. ठीक है? और नेचुरल लॉ नेचर में है, उसको हम समझते हैं रीजन से. वी अंडरस्टैंड इट बाय रीजन. तो अगर इफ यू विल रीड मेनका गांधी केस जजमेंट, what judiciary said? Judiciary said that you cannot make any law. Okay? Every law or law has to meet the criteria of due process of law, which means law has to be fair, just and reasonable. ठीक है? You cannot make unfair, unjust and any fanciful law. कोई भी दिमाग में आया लॉ बना दिया, ईसा मीसा वीसा. यू अंडरस्टैंडिंग दिस? तो ये मीसा वीसा सब गलत है, ये तो अनफेयर लॉ है, इसका कोई रीज़न नहीं है. दिस इज नॉट द वे दैट यू कैन डिटेन अ पर्सन. यू आर अंडरस्टैंडिंग दिस? सो अंडर ड्यू प्रोसेस ऑफ लॉ, जनरल स्टडीज़ के लिए सबसे सिंपलेस्ट याद रखना है, जुडिशरी कैन चैलेंज द विजडम ऑफ लेजिस्लेचर. एंड जुडिशरी का मेन जुडिशरी का काम क्या है? लॉ देखो और लॉ के हिसाब से जजमेंट करो. जुडिशरी यहाँ क्या करने लगता है? लॉ है, लॉ ही सही है कि नहीं, लॉ तो बाद में देखेंगे और जजमेंट करेंगे. तुमने लॉ सही बनाया कि नहीं? इज दिस क्लियर? सो अब लॉ सही है या गलत है कैसे डिसाइड करते हैं? जजेस. जजेस, you have to depend on the reason of judges. Judges का जितना दिमाग, you understanding this? तो judges का reason के लिए judges किसकी बात सुनते हैं? Their conscience या their conscience, soul. सोल ही तो है नेचर और गॉड. तो जज को क्या है? जज लिसन टू योर सोल. इफ योर सोल सेज दिस लॉ इज अनरीजनेबल, गवर्नमेंट तो इमरजेंसी लगा के ईसा मीसा सब पीसा ले आएगी, यहाँ पीस देगी. यू अंडरस्टैंडिंग दिस? तो क्या करना है? जजेस को देखना है कि भाई दिस लॉ इज रीजनेबल और नॉट. इफ यू डोंट फाइंड दिस लॉ रीजनेबल, then invalidate the law. You have understood? Due process of law. What is the criteria of due process of law? Fair, just and. This is very subjective term. Some judges may have more reason, some may have less reason. So this is going to vary from judge to judge. This is the problematic aspect. What is a good aspect? It provides bigger protection to the rights of the people. Is it clear now? You took this issue, fundamental freedom and liberty, and see from where we reached where. Okay. Now it is clear. अब कल फिर से पूछोगे क्लास के बाद? अभी पूछो. Everybody is clear? तो अगर कॉन्स्टिट्यूशन यू विल अंडरस्टैंड बाय लॉजिक, देयर इज नथिंग टू लर्न, यू विल नेवर डू एनी मिस्टेक इफ एवरी वर्ड एंड इट्स मीनिंग एंड द लॉजिक यू अंडरस्टैंड. देयर वाज या व्हाट? लेजिस्लेटिव. लेजिस्लेटिव एक्ट होता है लेजिस्लेचर मेक लॉ, executive implement the law. Is this clear? So, yeah. Reason. If judge find the law is not reasonable, it can struck down the law. No. In procedure established by law, judge can check only executive power, not the power of legislature. तो ब्रिटेन में क्या है? प्रिंसिपल ऑफ पार्लियामेंट्री सॉवरेनिटी. ब्रिटिश पार्लियामेंट कैन मेक एनी लॉ. जुडिशरी कैन नॉट क्वेश्चन द विजडम ऑफ लॉ देयर. इन इंडियन कॉन्स्टिट्यूशन we are not talking about amendment here. Why? Supreme Court cannot question what? Supreme Court in India cannot question amendment. Supreme Court of India is the only court in the universe to question amendment. और किसी कोर्ट, इसीलिए तो if you make amendment according to the judges, they are okay. If you don't make amendment, Supreme Court is the Supreme Court of India is the strongest court in the world. Why? Because this is the only court where court can challenge even the amendment. 99 तो है ही है, यही तो डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर है. Yes? Pardon? Judicial overreach, judicial activism, we can discuss later. You have to understand the meaning of these terms, that only we can talk about them. Okay. So, yes. Due process of law has no relation with the affirmative action. By due process of law, you mean only one thing. What is that? That judiciary can challenge the legislature. Okay? Fine. So it is enough for today? You will remember by tomorrow this? Okay? So what is the class timing? क्या बताया? 2:30 से 5. बिल्कुल 5 याद है, मतलब 5:30 तक पहुंचोगे ही नहीं. कोई बात नहीं आज के लिए. तो so tomorrow we will further continue with these terms. Okay? Any difficulty? तो पॉलिटी में कुछ याद नहीं करना होता है, सिर्फ वर्ड से लॉजिक को समझना होता है. ठीक है? तो कई लोग कहते हैं आर्टिकल रटे, आर्टिकल वार्टिकल, क्या कुछ भी रटना ही नहीं है. डोंट ट्राई टू मग अप एनीथिंग. इफ यू विल मग अप, you are certainly going to do the answer wrong. बहुत, it is dangerous if you will mug up, because then you will tend to commit mistakes. You will not even think. तो कोशिश करो एग्जाम में I will think and attempt. Okay? Judiciary क्या? System of legislature. But judiciary कह सकती है this law you have not made right. हाँ, तो वही तो है. It is judges, up to judges. This concept is not complete. I'll explain it tomorrow. No. Law and ordinance, same thing. By ordinance also you cannot do what judges don't want. Ordinance को challenge कर सकते हो? Only Supreme Court can review its judgment. No other. There is, इसीलिए तो Supreme